Eagle-Tribune Publishing Company.
Good morning.
Good morning, Mr. Caruso.
May it please the Court. I am Peter Caruso. I represent the Eagle-Tribune Publishing Company. I have with me my son, Peter Caruso II, who is on brief and also co-counsel. Closed, private, secret Clerk-Magistrate probable cause hearings are unconstitutional. Section 3:15 of the District Court Standards of Judicial Practice states, in part, presumptively, hearings ought to be private, rather than, presumptively, hearings ought to be open. This 1975 standard has the law backwards. There is a presumption that preliminary criminal hearings ought to be presumed open to the public unless under a quartet of U.S. Supreme Court decisions.
Mr. Caruso, you spend a lot of your brief arguing, trying to establish that these are preliminary criminal proceedings. Why does it make a difference whether they're criminal or civil? Aren't civil proceedings supposed to be open to the public as well, unless very strict rules are followed and the judge makes specific findings?
Yes, they are, Your Honor.
So why does it matter whether it's a criminal or a civil proceeding?
The issues primarily concern criminal procedures, but I welcome that the Court will use the same standards as criminal and civil. Criminal, traditionally, historically, have been granted more openness than some civil cases, especially in preliminary hearings.
But civil cases, unless there's a statute, like as in the case of juveniles, they're all open to the public, too. I mean, that's why I don't see why it makes such a big difference whether it's a criminal or a civil proceeding.
Of course, the juvenile court is closed by statute.
That's what I said.
Yes.
But I said unless there's a statute, such as in the juvenile case, civil proceedings are open as well.
I agree.
But I take it, do I understand that your claim is strictly a First Amendment claim at this point? That's what you've argued, First Amendment.
It's a First Amendment access claim.
First Amendment access. It's not a common law claim. It's not a...
Well, What's happened here on the First Amendment, of course, states that Congress should make no law abridging the freedom of the press. And since that time, the Supreme Court has, through case law, developed the First Amendment. And as part of that, there's been, since 1980, a quartet of Supreme Court cases specifically stating that criminal proceedings under the First Amendment should have access. And then the Press Enterprise 2 case stated that preliminary hearings should, in fact, have the same access requirements.
Well, what these clerk magistrates do is they hold these show cause hearings before criminal complaints issue, right?
Yes.
And in a lot of the cases, they're able to get it settled by somebody agreeing to do this or do that. Other cases, they say, no, there's no probable cause, I won't issue the complaint. Still other cases, they say, yes, there is probable cause, I'll issue the complaint that you want, or I'll issue a complaint for something else. That's sort of the way it goes, isn't it?
Well, Your Honor, we don't know.
We don't know, but that's...
Because we can't get in.
From experience, of what has happened after these proceedings in various courts, that's what usually occurs, one of 3 or 4 different things.
Well, one of three could happen, Your Honor. First, the clerk can continue the case.
Yeah.
Secondly, the clerk can, in fact, issue the complaint, or the court can, in fact, not issue the complaint. But why we're here, our argument would be that these clerk hearings have the same indicia as a preliminary hearing.
Well,
they, in fact, have gone beyond that.
No, they don't in many ways, because the defendant doesn't have the right to counsel. I mean, you say in your brief over and over it's like a trial, but it's not like a trial. It doesn't have the indicia of trial. The defendant does not have the right to counsel. The complainant may or may not come in with counsel, depending on what they choose. There is no right to cross-examine in the show cause hearings. None of the rights of trial. It doesn't have any of the attributes of trial, except that there are 2 parties there. There's no particular burden of proof, even. I mean, it's nothing. It's not a trial.
But it is quasi-judicial.
Actually, Your Honor, that's not correct. On a clerk's hearing, the application is made by the police department. A hearing goes out. The accused has a right to counsel.
Has the right, but you can go forward if he doesn't want to bring.
But in the hearings that we have been involved with, see, some of these are really secret hearings.
And the police or the complainant may not have any lawyer there.
But in this room, you have the clerk, you have the accused, you have the accused counsel, you have the police department, you have witnesses. You have witnesses that can, in fact, be subpoenaed by the court under the statute, under 21837, the clerk actually has the right to subpoena witnesses. So you have witnesses. You have multiple witnesses. As an example that the public now knows, in the Red Sox-Yankee brawl, which was going to be a closed clerk hearing, and we actually had petitioned the court and actually had to sue, but got that hearing. In that specific instance where you can actually see, you have all the players at counsel. They certainly were able to cross-examine. You had witnesses. Now, in a typical clerk's hearing, Your Honor, we have, not only do we have witnesses, we have evidentiary hearing, we have graphs, we have hospital reports, we have accident reports.
The witnesses are sworn, I would assume. Well, obviously, they
No,
must
they're
be.
not. Sometimes.
Sometimes?
Yep.
It's
supposed to be, it started out to be very informal, and I agree. But what's happened, these hearings have morphed into almost an indicia of a full-blown trial. These are preliminary hearings, Your Honor.
You have two conflicting concerns here, it seems to me. On the one side, you want to protect someone who was unjustly accused by having a private hearing, because you can have people who have trouble with reality, making false, very serious complaints against people, and if the clerk says there's not even enough here to go forward, you want to protect people in those instances. Or if it's a neighborly dispute and you can just get rid of it, there's no sense to having it all out in the public. But against that, the right of access always increases the likelihood of a fair disposition, and it also gives the appearance of a fair disposition if you have the right of access. So it seems to me those are the things that we have to balance here.
The right of access, the public, anytime the public is in a courtroom, that not only gives the appearance of fairness, but at least in America, I think that that's a right to be present in a courtroom. However, to get back to whether or not there's a right of privacy, I think the standard, Your Honor, has it again backwards. I think the standard should say that there should be a presumption of openness. Now, if there's a particular case in which a privacy right occurs, then in fact the clerk-magistrate can invoke that and close the hearing. But the way the standard, and it's only a standard, by the way, it's not a statute, not a case, it's only a standard. It does not appear in any statute, it does not appear in any case, it's a standard. This standard presumes that it's closed. Now, in a presumption of close for a clerk-magistrate's hearing, to them that's mandatory.
Isn't it true, is it true that a lot of the clerk magistrates aren't lawyers? Or do you know, is the one in this case?
That is correct.
Is the one involved in this case a lawyer?
She is not, Your Honor. That is correct.
That creates a little bit of a tension too, doesn't it?
Well, it does, but under the statute, an application for a criminal complaint can be heard by a judge.
Well, it's true.
I take it also can be appealed to a judge, right?
Right.
Yes,
If a complaint is not issued, that can be appealed to.
that's correct. It can
And
be
that's
heard by a
one-
judge and can be appealed to a judge.
That is one protection you have if there's a closed hearing and the Commonwealth is dissatisfied or the complainant is dissatisfied, there is an immediate right of appeal to a judge.
Well, in a closed hearing, Your Honor, we don't know what happened.
Well,
We don't
you'll
even know that
if
there was
the
a hearing.
complaint is denied.
That's the whole issue.
You'll know if the complaint is denied.
Sometimes we don't even know, they won't even tell us that there's a complaint, that there's been this matter before the court.
Can you get copies of the applications for complaint at any time?
And not before, Your Honor.
Not before they're decided?
No, because it hasn't got a docket number. Now, you say, well, why is Attorney Caruso here on these kinds of cases? There are some very important cases that have come before us in which we haven't been able to get in, such as the Red Sox-Yankee brawl case. We attempted to have access to the clerk's hearing, and we had to actually file suit in court to gain access for the Attorney General to then grant us access.
Sure, because the standard says you don't have access. So if you're going to get there, you've got to file suit.
It doesn't say that. That's what the clerks, exactly, Your Honor, that's what the clerks interpret the standard to say. But the standard says that presumptively hearings ought to be private. There's a presumption.
So
now,
they-
if I submit, which I did in the Red Sox case, I submit a 14-page brief to the clerk and said, I think I can overcome the presumption. He says it's never open. It's okay. So to them, it's mandatory. I'm saying it's not mandatory. The presumption is just wrong. Now, if, as Judge says, there are privacy issues that need to be balanced, the Supreme Court has actually talked about that. And it's a conditional right. It's not an absolute mandatory right of access. It's a conditional right. If there are privacy issues to be balanced, balance them. But the standard, and it's only a standard, and as this Court has said in the Norrell case, a standard cannot have the force of a statute or of law.
Well, that's well established. How long has this standard been around? The
1975, Your Honor.
Well, I was going to say, the practice of not opening these hearings has been around a long time.
Well, I've asked about this. So I've asked people a little bit older than I, but perhaps before 1975, and at times what happened, Your Honor, they would go before the clerk and they would present their argument and they'd say, okay, should a complaint issue? And right over the counter, the court would say, no, I'm not going to issue a complaint. Then it morphed into a closed room in which there'd be an informal hearing. But today, Your Honor, you have counsel, you have evidence, you have cross-examination, you have testimony, and this has become an adjudicatory hearing. It's morphed beyond that. And other courts have addressed this, as well as the Supreme Court.
How do you know you have all those things?
Because of how, thank you. We have been successful in several cases. So we have in fact been,
Well, the clerk,
Statute 21835A says what you have.
Yes.
It's in the statute.
Yep.
It doesn't, is not dependent on.
21835A and 21837.
Right.
So there is a statute.
Right.
But how do I know, Your Honor? Good question. Because we've been successful in several cases.
And you've gone in there.
We're sorry. So we've seen, in one case, there were 5 lawyers, because it happened to be with high school students had vandalized a school. It was going to be a clerk's hearing. It was major publicity. Everyone had an attorney, and it was going to be closed. We had petitioned the Clerk-Magistrate, and that hearing was in fact open. And that was held in a courtroom, and it was held just of all the indicia of a probable cause hearing. You had witnesses, cross-examination, you had evidence, you had people talking back and forth. The complaint, it was always issued, not always, but it was
How many of
issued.
the other states, if you know, have open hearings? Or if do they have some kind of a rule which allows them to close the hearings under certain circumstances? And if that's true, what circumstances are they?
We have tried to research that, and this type of a hearing in Massachusetts is almost unique. Other courts have probable cause hearings. Some have hearings before an application.
You mean
But they-
probable cause adversary hearings?
Yes.
Right to
adversary.
cross-examine.
And they're open, yes. As we do here, even though, as the Justice had mentioned, that there is no right, but in fact, that's what happens. In reality and practice, these hearings are very much
Of course, the only
like a
ones that
trial.
the paper's going to be interested in are the high-profile ones, like the Red Sox.
That's
or
correct, Your Honor.
This one here, or the mayor's son, or whatever.
Well, the mayor's son, we've been denied some hearings where you have a police captain files a complaint against a police chief. We had a head-on collision in which a mother and her baby died, and that head-on collision, there was adjudication. That was in a closed hearing. The public wants to know, and we still don't know what went on in that closed hearing. Now, when you say that there's
well, was the complaint issued? You say a complaint wasn't
complaint was
issued.
not issued in that case, Your Honor. Okay, but we don't know why. But here you have someone
Well,
going
the
down.
Commonwealth clearly could appeal that. In fact, the Commonwealth could just go and directly indict. They don't even need to comply with this process.
Certainly. But if they go that route, the public has a right. And again, this is questioning merely the standard. I think the standard has
The
it
public
backwards.
has a right once formal process is issued. Once a complaint is issued, a criminal proceeding has started, or once an indictment has been rendered, of course.
That's actually not what courts have stated, and I submit that in this particular case, Your Honor,
But what have courts stated on pre-complaint proceedings, before a criminal charge has been brought?
I wish I could find a court that had said
Yeah,
pre-complaints.
because the cases that you cite deal with probable cause hearings for the most part, which is different. You have a right of access. Nobody questions that to a probable
Your Honor
cause.
says that they're different. However, both in the standard and in the statute, nowhere does it say show cause hearings. They're all termed probable cause hearings.
Yeah, the probable cause to arrest hearings, really, I think.
But they're right.
technically.
They're probable cause as to whether the complaint should issue.
And in that, the U.S. Supreme Court has stated, it is important to note that not consideration of issues presented in the instant case of the First Amendment question cannot be resolved solely on the label we give the event.
Yeah, and we're not, actually, that's why I'm trying to get beyond the label, because you're using the label probable cause, the clerks use the label show cause. I'm trying to figure out, what is this? This is a pre-complaint hearing.
But
And
this
whether-
hearing is much more, it's similar to a trial. You have cross-examination, you have witnesses, you have testimony.
Well, it's a hearing to ascertain whether probable cause exists to issue any kind of complaint, isn't it?
Yes, but that
So it is
hearing
sort-
You
is...
don't have the right to cross-examination. I just looked in the statute. The clerk can say at these hearings, can let the complainant testify, and then the clerk can say, oh, I believe her, she's made out the elements, goodbye, I'm issuing the complaint. That happens, and that is permissible. And so there isn't it's not at all like a trial. There isn't a right to cross-examine. It can end without any cross-examination, and I'm sure many times it does.
In reality, there was a full-blown hearing. In the cases that we've been involved with, which have been now about 10 or
These
12.
ones over the counter, and there still are, I'm sure, in some.
But again, it's just the standard that we're questioning, Your Honor. I believe the standard is improperly worded. If the standard was that there's a presumption of openness, then the clerk can certainly close it. There is no.
So what are you saying, that if the right to cross-examination is afforded, then the hearing should be open to the public?
If there are attorneys present, if it's similar to an adjudicated process, yes, Your Honor, because there's more going on than just the clerk looking at a complaint. It's risen to a state of a trial stage, and this is the only opportunity that the public or anyone would have an opportunity to hear what happened, and in some cases.
Thank you, Mr. Caruso. Thank you.
You're welcome, Your Honor.
Ms. McLaughlin? What is the big deal about opening these things up to the public? The press isn't going to come unless it's a cause célèbre, like we've been talking about, the Red Sox, the mayor's son, something like this. The run-of-the-mill ones, they're not even going to bother with. What is the big deal? Everything else in the judicial system, except for a few very limited circumstances, like juvenile cases and so on, are open. This is quasi-judicial, correct?
This is quasi-judicial. I think the deal is that these are entirely different than most other criminal proceedings. These are at a point in the proceeding where there has not even been met the very low threshold of determining whether the statements made by the accuser meet the elements of a crime and whether there's any probable cause to believe the accused has committed that crime. At that stage, as Your Honors have pointed out, there is a fair deal of information that comes before a clerk-magistrate, which really is in the nature of neighborly disputes, domestic complaints, and there's a privacy right of the accused.
That's fine, and the newspaper isn't even going to bother going to any of those.
Well, what about when some person makes a complaint of sexual abuse against a well-known person, and suppose it's totally ungrounded, and the newspapers are going to be there, and they're going to print it all over the front page, and the complaint may not issue. And I think that that's something that is a serious issue that we need to be cognizant of, which we need to be cognizant.
If the accuser or the complainant is able to meet the very low threshold, and it should be noted this is a lower standard than at post-complaint probable cause hearings. If all that a complainant needs to show at a show cause hearing is that his or her complaint states the elements of some crime and that there is probable cause to credit the allegation that it was the accused who committed this. Once that very low threshold has met, a complaint will issue, and at that point, the proceedings do become open and accessible to the public.
Are you familiar with this case he talked about, which I'm not familiar with, maybe you are, about some accident involving the police, a policeman or the police chief, and a woman and a child, and the woman and child were killed, and that went to one of these things and nothing issued, and everybody must be wondering what in the world went on.
I am not familiar with that, Your Honor.
See, it's those kinds of cases that cause the difficulty in the system, where allowing people in might be okay.
I think, though, a certain amount of discretion has been wisely vested in the clerk magistrates in these cases. As it said, if there is a situation where there is a serious charge, as Your Honor's noted, the Commonwealth may proceed by indictment or arrest.
Well, what if there's a request, if a complaint does not issue and there's a request to have a judge decide the question whether a complaint should issue? Is the hearing before the judge open to the public?
I'm sorry, I'm not sure about.
Yes, it is.
It is, Your Honor.
Yeah.
Yes.
So if it's the same case and it's the same question, and the only difference is it's heard by a judge as opposed to a clerk, what's the rationale between closing the clerk's hearing?
Well, the rationale for closing the clerk's hearing is simply that this is, by and large, a procedure, these clerk hearings, instituted by statute, which is to try to enable a Clerk-Magistrate to screen out of the criminal justice system at the earliest possible opportunity cases which aren't actually really criminal in nature or which don't belong there. The Clerk-Magistrate is implicitly entitled to attempt to have the parties seek a resolution of this, that there's some element of counseling involved in all this, that there is a privacy concern, and these are not anything like criminal trials. There is no right of cross-examination. Their rules of evidence are not followed. It's a very low threshold to be met, whereas in probable cause hearings which occur after the complaint, all the trial-type protections which have been discussed do adhere. Their rules of evidence are applied to. Defense counsel has the right to cross-examine. It's a higher.
We're really talking about probable cause to proceed based on admissible evidence at that stage. Here we're talking about really, it's a probable cause to arrest standard is what we're talking about.
Very much so. At this show cause stage, it's a probable cause to arrest type standard. At the post-complaint probable cause hearings, it's more like the test that a judge employs to look at a required finding of not guilty, i.e. sufficient admissible evidence to the jury.
If we were to say that the presumption should be the other way, that the presumption should be that these hearings are open unless certain findings are made or unless certain conditions are met, what would you suggest the conditions be?
If this court were to find that these hearings are sufficiently trial-like, that a qualified First Amendment right of access attaches, as in the press enterprise cases, then I believe that it would have to follow the First Amendment test for closure, i.e., is there a compelling state interest and is closure necessary to meet that state interest? However, the position of the respondents in this case is that these cases do not fall under the umbrella of the quartet of Supreme Court cases because they are not anything like criminal trials. And that
Mr. Caruso suggested that if the right of at least if I understand him correctly, if the right of cross-examination is afforded, doesn't have to be, but if it is afforded and it takes on the aura of a trial or of an adversary proceeding, then they should be open. Do you disagree with that?
I think that it's not just the right of cross-examination. I think that the factors in the El Vocero case and the press enterprise case taken in their totality were looked at to show that these were like criminal trials. For example, in those two cases, there was not only a right to cross-examine witnesses, there was a right to exclude illegally obtained evidence. The prosecutor was involved, the rules of evidence were followed, and there were discovery procedures available. I think that if this court were to examine this, it would have to look at more than just any one factor. It would have to look at the proceeding as a whole to determine whether these are sufficiently like criminal trials.
But the clerk, when they're looking at these things and holding these kinds of hearings, I know they're not making evidentiary rulings, but aren't they looking to see if whatever the complainant is talking about is supported by admissible evidence?
I believe they are only looking to see whether there is some...
I mean, suppose, for example, I go in and I say, well, my neighbor cut down my trees, so I want a complaint for malicious destruction of my property. And the clerk says to me, how do you know he did it? And I say, well, I don't like the guy. He must have done it, but I didn't see him do it. So I've got no identification. It's kind of speculation on my part. Isn't the clerk saying, geez, this guy doesn't have any admissible evidence to support this complaint?
I think that the clerk, unless you had some sort of circumstantial evidence in that case, if there's absolutely nothing there other than the complainant's own.
Well, I got the legal elements
of
to follow your reasoning. I got the legal elements of the complaint, malicious destruction of property, but I've got a gap on proving identity because I can't show by admissible evidence he did it. So I guess my point is the clerk has got to look for admissible evidence while he's holding this hearing.
He's got to find if there's evidence that there's some evidence to meet the probable cause threshold that the person you are accusing is in fact.
So there is a little evidentiary quantity to these hearings. very often the clerks, if it's not actual cross-examination, will say to whoever the party being complained against is, or their lawyer, you can ask a few questions if you want, right? So that's not formal cross-examination, but it's a little bit of a questioning process, correct?
I think that does at times happen, and again, I would just point out that this is a very low threshold, that that there is no right to this type of hearing outside of, independently in the Constitution or the Declaration of Rights outside of the statute, and that it does
But
not...
the trouble is, though, these arise, they seem to arise in a lot of high-profile cases. We've mentioned some. And then everybody says, what is going on? Particularly when you have a non-lawyer clerk.
Well, I believe that the show cause hearing is only available in cases of a misdemeanor or a felony where the police proceed by means not without an arrest.
Correct.
So in any case where the police
That's
have
right.
had an arrest or where there has
An arrest
been...
by definition requires probable cause.
Right. But were there any situation where there has been an arrest or where there has been a grand jury indictment, which I would submit to the court, are the situations which are more likely...
But you do get
to be-
high-profile cases, like the Red Sox and the Yankees.
That was...
Cops down there didn't arrest anybody. They threw the whole thing, as they probably were entitled to and should have done, over to the clerk to sort out.
And the standards do provide for access in those types of cases. Standard 316 provides that where the matter is of, the clerk determines that the matter is of substantial public interest and that the public's legitimate interest outweighs the rights of the accused to privacy, then the proceedings may be made open to the public. And
But why wasn't that done here?
Pardon me?
This sounds like a pretty good case for the application of an open hearing.
The judge must have, the Clerk-Magistrate must have determined, I don't know, there are no findings on that fact. I know that the petitioners here...
Anecdotal information appears to be that they're not making those kinds of findings. They're not opening these things no matter what, until actual lawsuits are filed and the courts are saying, well, you got to open this one up. Anecdotally.
Anecdotally, there may be situations where that's true. I do acknowledge that in the Red Sox-Yankees case, the determination to make it public did occur after a lawsuit had been brought. That doesn't, however, render the statute unconstitutional.
That was my
Yeah,
point here. What we're
that's
dealing with is the challenge, saying that this standard violates the First Amendment. That's what we're dealing with. Is that right?
We are. And
So
there
we may, as a matter of judgment or in our exercise of supervisory authority, determine that the rules ought to be different, but there's a process that we can go about changing that.
Absolutely. I would submit that whether the legislature or this court or some committee of this court were to determine that there's a better way to do that is not the issue before this court here. The question on appeal today is whether this standard
Right.
meets constitutional
That's
threshold.
the issue, and we can't lose sight of that, and that requires us to look carefully at these 3 or 4 U.S. Supreme Court cases.
Yes, Your Honor. And I would submit that even if this court were to extend the umbrella of the Press Enterprise 2 test to the facts of the 35A show cause hearings, that these hearings do not meet the types of experience, they would not survive the experience and logic tests.
Well, they have historically not been open to the press,
Right.
so the Eagle-Tribune's argument fails on the first part of the test, but the second part is that public access has a significant positive role in the functioning of the particular process in question, the logic test, and maybe it does.
I would first note that this has been ruled, or at least stated in dicta, to be a conjunctive rather than disjunctive test, that the party seeking access must show that both prongs are met.
Right.
So if it does fail on experience, that ends the inquiry. One doesn't need to go to logic. However, if one were to go to the logic prong, I would go back to where I believe my discussion with this court started, which is there is a substantial interest expressed in the standard in protecting the privacy rights where these situations occur as this court has noted, often involving grievances relating to minor matters, involving the frictions and altercations of daily lives. I think that there is some interest in not opening up to the public potentially embarrassing, if ungrounded, criminal charges, and that also press and public scrutiny of minor matters which might be able to be resolved through counsel become intractable if the parties feel they're under the glare of scrutiny rather than just in a situation where the clerk-magistrate is trying to cause them to resolve their differences.
Okay, thank you, Ms. McLaughlin.